functions are open to achieve immunity. Its general purpose is always to enable Parliament to carry out its tasks without undue external interference. Relationship between parliamentary immunities and power. The immunities of the House and their members and the powers of the House, particularly the power to punish contempts, although referred together by the term parliamentary privileges, are quite distinct. The power of the House in respect of contempt is a power to deal with acts which are regarded by the House as offense against the House. That power is not an offshoot of the immunities, which are commonly called privileges, nor is it now the primary purpose of that power to protect those immunities which are expected to be protected by the courts in the process of ordinary law. Overview of parliamentary privileges, immunities, and power. The term parliamentary privilege refers to two significant aspects of the law relating to Parliament: the privileges or immunities of the House of Parliament and the powers of the House to protect the integrity of their process. These immunities and powers are very extensive. They're deeply ingrained in the history of free institutions, which could not have survived without them. The law of parliamentary privilege is particularly important so far as to Parliament is concerned, because it is the foundation of Parliament's ability to perform its legislative functions with appropriate degree of independence of the House of Representatives. Again, although in the Parliament vocabulary the words privilege and immunity are sometimes used synonymously, it is necessary to know there is a clear distinction between those two words. Parliamentary privilege refers to certain specified rights which members of Parliament are entitled to enjoy, such as the freedom of speech and debate inside the Parliament, while parliamentary immunity refers to a set of specified exemptions from the ordinary laws of the land, such as the immunity from legal proceedings for words spoken in Parliament and the immunity from a right of civil debts. Also, there is an important principle in this aspect, which is that parliamentary privileges, immunities, and power is part of the law of the land. Breaches of those are punishable by the courts of justice in exactly the same way as violation of other laws are dealt with. Wherever any of those rights or immunities is disregarded or violated by individual or authority, the offense is called breach of privilege and punishable under the law as contempt of Parliament, an offense which is similar to that of contempt of court, which is more familiar. This is the reason why the written constitution of many countries, especially the Commonwealth countries, including East African countries, have routinely included specific provision to cater for parliamentary privileges and immunities. Parliamentary powers, immunities, and privileges in Tanzania. In Tanzania, there's a statutory provision covering parliamentary power, immunity, and privilege, which found in Article 100 of the Constitution of the United Republic of Tanzania of 1997, which clearly states there shall be freedom of opinion, debate in the National Assembly, and that freedom shall not be breached or questioned by any organ in the United Republic or in any court or elsewhere outside the National Assembly. Subject to this Constitution or to the provision of any other relevant laws, a member of Parliament shall not be prosecuted, and no civil proceedings may be instituted against him in a court in relation to anything which he has said or done in the National Assembly or has submitted to the National Assembly by way of petition, bill, motion, or otherwise. Also, there is a Parliamentary Immunities, Power and Privileges Act 1988, number 3 of 1988, which was revised in 2020. The relevant of this paper will describe some of specific privileges and immunities as well as specific powers which are granted by this Parliament by law. Specific offences and penalties related to parliamentary privileges and procedures to be followed by dealing with breaches of parliamentary privileges which may be committed by non-members of Parliament as follows. Freedom of speech and debate in the House, Section 3 of the Act number 3 of 1988, revised in 2020, provide freedom to the members of Parliament and not to be liable to be questioned in any court placed outside the Assembly. The privilege of freedom of speech is not much intended to protect the members from persecution for their own individual advantage, but rather to support the rights of the people by enabling their representatives to carry out their duties inside the Parliament without fear of either civil or criminal prosecution. Immunity from legal proceedings, Section 5 of this Act, number 3 of 1988, provide immunity from legal proceedings, which no civil or criminal proceedings may be instituted against any member for words spoken before the Assembly or any of its committee, or by reason of any matter or thing brought by him therein by petition, bill or motion, or otherwise for the word spoken or act done bona fide in pursuance of a decision or proceeding of the Assembly or committee. Immunity from arrest for civil debts, Section 7 of this Act, number 3 of 1988, revised in 2020, provide freedom from arrest for civil debt to the members of Parliament, whereby a member shall not be liable for arrest for any civil debt except for debt that contracted which constitutes a criminal offense. The evidence of proceeding in Assembly or committee not to be given without leave, Section 10 of the Act number 3 of 1988, revised 2020, explain this privilege and justification since the Parliament has the paramount right, the attendance and service of its members. Any call for any member to attend elsewhere while House is in session should not be entertained. Example for this immunity was breached by 3 members of Parliament and 2 officials in criminal appeal case number 61 of 1999 of Honorable Agostino Liatonga, Mrema vs. the Republic. The relevant facts were as 3 members of the Parliament and 2 officials of Parliament have been summoned to give evidence in the High Court in the above-mentioned criminal case without seeking leave of the Assembly or of the Speaker as required by provision of the relevant law. The judge proceeded to the High Court and gave their evidence, and the trial judge duly admitted this evidence. When the case went to the appeal court of Tanzania, the appeal judges strongly criticized their behavior in the judgment for not conceded presence of a special leave from National Assembly. The power to regulate its internal affairs, the power of control over its own affairs and proceedings in one of the most significant attributes of an independent legislature. Article 89 of the Constitution of the United Republic of Tanzania grants the necessary powers to Parliament to make own rules which are known as standing orders, prescribe procedures for the conduct of business. For instance, Tanzania in court once did it when in dismissing Mrema application for a stay of implementation of a parliamentary resolution suspending him. Judge Katiti of the High Court of Tanzania declared, in obedience to Article 100, Section 1 of the Constitution of the United Republic of Tanzania, I hereby declare that this court has no jurisdiction to hear this petition. The power to enforce discipline on its members. This is to provide for a standing order number 83, apart from disciplinary measures, which are prescribed in standing order number 83, 1 and 2, standing order 84, 4, and number 85.